Hello class, this is Chapter 2, Constitutional Limits on Criminal Law.
The objectives we're going to cover in this chapter are as follows. First, to understand and appreciate the reasons for limits on criminal law and criminal punishment in the U.S. constitutional democracy. Second, to understand the principle of legality and its importance of its relationship to the limits of criminal law and punishment. And third, to appreciate the nature and importance of retroactive criminal lawmaking. We've also worked to know the criteria for identifying vague laws and to understand and appreciate their constitutional significance and consequences, and to understand and appreciate the rights defendants enjoy in criminal proceedings, the burden they have to support in their affirmative defenses, and the requirement of the prosecution to prove guilt beyond a reasonable doubt. We will also work to know, understand, and appreciate the limits placed on the criminal law and criminal punishment by the specific provisions in the Bill of Rights. To understand and appreciate the constitutional significance and consequences of the principle of proportionality in criminal punishment and its relation to cruel and unusual punishment. And finally, to understand the importance of the right to trial by jury in the process of sentencing convicted offenders.
Now we're going to talk about the principle of legality. There is no crime without law and no punishment without law. There is a ban on ex post facto laws, and it is spelled out in Article 1 of the U.S. Constitution. And it does one of three things. It criminalizes an act after the fact, increases punishment after the fact, and takes away a defense after the fact. And this is spelled out in cases Beazell versus Ohio in 1925. Let's talk about the ban on ex post facto laws. The purposes of the ban are to protect citizens and also to prevent arbitrary and vindictive laws. The authors of the Constitution considered the ban on retroactive lawmaking so important that they raised it to constitutional status in Article 1 of the U.S. Constitution. Most states' constitutions ban retroactive statutes. An ex post facto law does one of three things. It criminalizes an act that was not a crime when it was committed. It increases the punishment for a crime after the crime was committed, and it takes away a defense that was available to a defendant when the crime was committed. Specifically, a case involving Beazell versus Ohio in 1925. The ex post facto ban has two major purposes: to protect private individuals by ensuring that legislatures give them fair warning about what is criminal and that they can rely on those requirements. And secondly, to prevent legislatures from passing arbitrary and vindictive laws. Let's talk about the void for vagueness doctrine. What is void for vagueness? Vague laws violate two provisions, the 5th and 14th Amendments to the Constitution, and takes aim at two evils: failure to give fair warning and arbitrary and discriminatory law enforcement. A law is void for vagueness if it forbids conduct and prescribes punishments in terms so uncertain that ordinary people have to guess at their meaning before they choose a course of action. And one case that illustrates this is Lanzetta versus New Jersey, 1939. The U.S. Supreme Court has ruled that vague laws violate the guarantees of two provisions in the U.S. Constitution. Again, the 5th Amendment to the U.S. Constitution that guarantees that the federal government shall not deny any individual life, liberty, or property without the due process of law. And the 14th Amendment provides that no state government shall deny any person life, liberty, or property without due process of law. The reasoning behind the void for vagueness doctrine goes like this. The 5th and 14th Amendments ban both federal and state governments from taking any person's life, liberty, or property without due process of law. And criminal punishment deprives individuals of life, liberty, or property. Failure to warn private persons of what the law forbids and or allows gives officials the chance to arbitrarily define what the law forbids and denies individuals of their life, liberty, and or property without due process of law. The void for vagueness doctrine takes aim at two evils similar to those of the ban on ex post facto. First, void for vagueness laws fail to give fair warning to private individuals as to what the law prohibits. Second, they allow arbitrary and discriminatory law enforcement, again quoting or citing Lanzetta versus New Jersey, 1939. Fair notice in ex post facto laws is not that an actual defendant knows there's a law against the act, but that an ordinary reasonable person would know that the act is a crime. Despite the importance of giving fair notice to individuals, in 1983, the Supreme Court decided that providing, quote, minimal guidelines to govern law enforcement, end quote, trumps notice to private individuals as the primary aim of the void for vagueness doctrine. And this was cited in the case Colander versus Lawson in 1983. Now here's a discussion, question, or activity for you to consider. 1. What are the problems with vague laws? And 2. What can and has happened in the past when laws are so vague that an ordinary person cannot understand them? Now let's talk about the rule of lenity. This requires courts to resolve every ambiguity in a criminal statute in favor of the defendant. The narrow lenity rule requires courts to interpret ambiguous statutes in favor of defendants only in the core felony cases and other crimes requiring fault. As far as proving guilt in criminal cases, you must be able to prove criminal conduct, and there must be proof in justification and excuse defenses. Now let's talk about the Bill of Rights and criminal law. First of all, we're going to talk about the right of freedom of speech. This is in the First Amendment, and it involves expressive conduct. It applies to all states, and there are 5 categories of expression that are not protected. The First Amendment states that, quote, Congress shall make no law abridging the freedom of speech, end quote. The First Amendment commands thus. The U.S. Supreme Court has expanded the ban beyond this already sweeping scope. First, the court has expanded the meaning of quote-unquote speech by holding that the protection of the amendment, quote, does not end with the spoken or written word, end quote, and this was ruled in Texas versus Johnson, 1989. It also includes expressive conduct, meaning nonverbal actions that communicate ideas and feelings. Second, although the amendment itself directs its prohibition only at the U.S. Congress, the U.S. Supreme Court has applied the prohibition to the states since 1929 in a case called Gitlow versus New York. Third, the court has ruled that free speech is a fundamental right, one that enjoys preferred status. This means that the government has to provide more than a rational basis for restricting speech and other forms of expression. It has the much higher burden of proving that a compelling government interest justifies the restrictions. Despite these broad prohibitions and the heavy burden the government faces in justifying them, the First Amendment doesn't mean you can express yourself anywhere, anytime, on any subject, in any manner. According to the U.S. Supreme Court, there are 5 categories of expression that are not protected by the First Amendment. 1. Obscenity. 2, profanity, 3, libel and slander, 4, fighting words, 5, clear and present danger. And 6, the First Amendment does not protect these forms of expression because they're not a, quote, essential element of any exposition of ideas and are of such slight value as a step to truth that any benefit may be derived from them is clearly outweighed by the social interest in order and morality, end quote. And this was ruled upon in Gitlow versus New York, again in 1925. The most difficult problem in making a crime out of speech and expressive conduct is when laws reach so far that they include and not just expression that the Constitution bans, but also expression that it protects. The void for overbreadth doctrine protects speech guaranteed by the First Amendment by invalidating laws so broadly written that the fear of prosecution creates a quote-unquote chilling effect that discourages people from exercising that freedom.
Now let's talk about the Second Amendment, or the right to bear arms. For most of our country's history, the Second Amendment was absent from the Supreme Court's agenda. When arguments based on the amendment reached the court, they were ineffectual. One example is Cook, Ludwig, and Samaha in 2009. In 2008, the U.S. Supreme Court case, the District of Columbia versus Heller, became the first successful Second Amendment challenge in the court's history, a full 207 years after the amendment was ratified. Again, that was Cook, Ludwig, and Samaha in 2009 that was ineffective, but District of Columbia versus Heller was. In court, in McDonald versus City of Chicago in 2010, the Supreme Court made clear that the right recognized in Heller fully applied to state and local governments, and it reiterated that its decision in McDonald did no more than apply its Heller holding to the state and municipalities and struck down the Chicago ordinance because, like the D.C. ordinance, it banned the following possession by law-abiding citizens with functional handgun in their own homes for the purpose of self-defense. According to the majority, quote, like most rights, the right secured by the Second Amendment is not unlimited. The right is not a right to keep and carry any weapon whatsoever in any manner whatsoever and for whatever purpose, end quote. It then provided a list of examples for which it made clear it was not exhaustive, such as bans on carrying concealed weapons, felons possessing firearms, the mentally ill possessing firearms, carrying firearms in sensitive places such as schools and government buildings, and laws imposing conditions and qualifications on the commercial sale of arms. Heller is an important decision for at least 3 reasons. It renders the first clause of the amendment irrelevant, a well-regulated militia being necessary to the security of a free state. It doesn't rule out expanding the right beyond the narrow boundaries of Heller and McDonald's. It is a litigation magnet. The court has left it to lower courts to determine.
Unlike the rights to free speech and to bear arms, which are clearly spelled out in the First Amendment, you will not find the word privacy anywhere in the U.S. Constitution. Nevertheless, the U.S. Supreme Court has decided there is a constitutional right to privacy, a right that bans, quote, all governmental invasions of the sanctity of a man's home and the privacies of life, end quote. This was ruled on in Griswold versus Connecticut in 1965. According to the court, Griswold versus Connecticut in 1965, the fundamental right to privacy originates in 6 amendments to the U.S. Constitution. 1. The First Amendment rights of free speech, religion, and association. 2. The Third Amendment ban on the quartering of soldiers in private homes. 3. The Fourth Amendment right to be secure in one's, quote, person, house, papers, and effects, end quote, from, quote, unreasonable searches, end quote. 4th, the Ninth Amendment provision that the, quote, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." End quote. Number 5, the 5th and 14th Amendments due process right to liberty. And 6, this cluster of amendments sends the implied but strong message that we have the right to be let alone by the government. Following Griswold, the court decided several controversial cases based on the right to privacy. 1, Stanley v. Georgia, 1969. 2, Eisenstadt v. Baird in 1972. 3, Roe v. Wade in 1973. 4, Carey v. Population Services International, 1977. 5, Planned Parenthood v. Casey, 1991. And 6, Lawrence v. Texas in 2003.
This is Table 2.1, the U.S. Supreme Court and the right to privacy, from Griswold to Lawrence, and it lays out some very important cases. The first is the one we talked about, which is Griswold versus Connecticut in 1965. The decision was that it struck down laws making it a crime for married couples to use contraceptives and to counsel couples on birth control. The second is Stanley versus Georgia in 1969, which struck down a state law making it a crime for adults to possess pornography in the privacy of their homes. The third is Eisenstadt versus Baird in 1972, which invalidated a law banning distribution of contraceptives to unmarried persons. There's Roe versus Wade in 1973, which struck down a law banning abortions. Carey versus Population Services International in 1977, which struck down a law banning the use or sale of contraceptive devices to persons under the age of 16. Then there's Planned Parenthood versus Casey in 1991, which struck down a law requiring a pregnant wife to notify her husband of her intention to abort a fetus. And Lawrence versus Texas in 2003, which struck down a Texas statute making adult consensual same-sex sodomy a crime.
Now here's a discussion activity that you need to put yourself through. The Supreme Court has decided that the right to privacy is a fundamental right that requires the government to prove that a compelling interest justifies invading it. How has the court used the various amendments to provide citizens with this right? Has the court overstepped its bounds regarding some issues? So these are questions that you need to consider. Now let's talk about the Constitution and criminal punishment. In regards to barbaric punishments, punishments are considered no longer acceptable to civilized society, and that's what defines a barbaric punishment. At the time the amendment was adopted, these included burning at the stake, crucifixion, breaking on the wheel, torturing or lingering death, drawing and quartering, the rack and screw, and extreme forms of solitary confinement. For more than 100 years after the adoption of the Bill of Rights, no cruel and unusual punishment cases reached the U.S. Supreme Court because these medieval forms of execution were not used in the United States. In the Kemmler decision, the court defined what cruel means in the 8th Amendment. According to the court, punishment by death isn't cruel as long as it isn't, quote, something more than the mere extinguishment of life, end quote. The court spelled out what it meant by this phrase. First, death has to be both instantaneous and painless. Second, it can't involve unnecessary mutilation of the body. So, according to the court, beheading is cruel because it mutilates the body. Crucifixion is doubly cruel because it inflicts a lingering death and mutilates the body. Continuing with the Constitution and criminal punishment, let's talk about disproportionate punishments. In other words, the punishment should fit the crime. And there were two particular rulings that you need to read about. The first is Weems versus the United States in 1910 and Robinson versus California in 1962. Disproportionate punishment means that the punishment should actually fit the crime and should not be disproportionate to the crime committed. The U.S. Supreme Court first applied proportionality as a principle required by the Eighth Amendment in Weems versus the U.S. in 1910. In extending the cruel and unusual punishment ban to state criminal justice in the 1960s, the court in Robinson versus California, 1962, reaffirmed its commitment to the proportionality principle. The court majority ruled that a 90-day sentence for drug addiction was disproportionate because addiction is an illness, and it's cruel and unusual to punish persons for being sick. As far as the death penalty, death is different. A majority of the U.S. Supreme Court has consistently agreed that the proportionality principle applies to death penalty cases. As the court puts it, quote, death is different. The death penalty for mentally retarded murderers is addressed separately. The American Association of Mental Retardation, or AAMR, includes 3 elements in its definition of mental retardation. A, the person has substantial intellectual impairment. B, that impairment impacts the everyday life of the mentally retarded individual. And C, retardation is present at birth or during childhood. This was ruled on in Atkins versus Virginia in 2002. In Atkins versus Virginia, the U.S. Supreme Court ruled that executing anyone who proved the 3 elements in the AAMR definition applied to them violated the ban on cruel and unusual punishment. As far as the death penalty for juvenile murderers, until 2005, the death penalty was considered constitutional. In 2005, the court decided on whether standards of decency had evolved enough since 1989 to be offended by executing Christopher Simmons for a carjacking murder he committed when he was 17. This is Roper versus Simmons in 2005. In this case, by a vote of 5-4, the U.S. Supreme Court held that the 8th and 14th Amendment forbid the execution of offenders who were under the age of 18 when they committed their crimes. This is a discussion activity for you to work on and consider. The 8th Amendment protects people from excessive punishment and codifies the principle that, quote, punishment should fit the crime, end quote. What special considerations are made when the penalty is death? Are there any considerations that the Supreme Court has made that you disagree with? And are there any considerations that should be included that are not?
Continuing with the death penalty and death being different, does the proportionality principle extend to sentencing juveniles to life who don't kill? The U.S. Supreme Court said yes in Graham versus Florida in 2010. The consensus that the ban on cruel and unusual punishment includes a proportionality requirement in capital punishment does not extend to prison sentences themselves. The important case of Solomon versus Helm in 1983 revealed that the Supreme Court was deeply divided over whether the principle of proportionality applied to sentences of imprisonment. The split over the constitutional status of proportionality in prison sentences was revealed again when the constitutionality of 3 strikes and you're out reached the court in 2007. In Ewing versus California, the court upheld the constitutionality of California's 3 strikes law. 3 strikes are an example of one kind of sentencing scheme in the United States, that of mandatory minimum sentencing.
Now let's talk about the right to trial by jury and criminal sentencing. Until 2000, the guidelines and mandatory forms of fixed sentencing created only possible cruel and unusual punishment problems. Beyond that, the U.S. Supreme Court took a hands-off approach to sentencing procedures, leaving it up to state legislatures and judges to share sentencing authority and administration without interference from the court. Then came Apprendi versus New Jersey in 2000, and this was called by two authorities, Dressler and Michaels, in 2006, which was, quote, the first in a series of constitutional explosions that have rocked the world of criminal sentencing and caused fundamental alterations, end quote, in federal and state sentencing systems. The U.S. Supreme Court, by a judgment of 5-4, brought the Sixth Amendment right to trial by jury into the heart of criminal sentencing procedures with a sweeping rule, which is called the Apprendi Rule. Other than the facts of prior conviction, any fact that increases the penalty for a crime beyond the prescribed statutory maximum must be submitted to a jury and proved beyond a reasonable doubt. Between 2000 and 2005, the Supreme Court extended the Apprendi Rule. In a series of 5-4 decisions made up of shifting member majority and dissenting justices, the court stirred up uncertainty and anxiety about the effect of the rule on state and federal proceedings, particularly on the by now firmly established U.S. and state sentencing guidelines. In Blakely v. Washington in 2004, by a decision of 5-4, the court struck down a Washington state statute that allowed judges to increase the length of prison time beyond the, quote, standard range, end quote, prescribed in the Washington sentencing guidelines based on the facts not proven to a jury beyond a reasonable doubt. In U.S. v. Booker in 2005, the court applied the Apprendi Rule to the U.S. sentencing guidelines. Therefore, the court held, judges can't increase a defendant's sentence without proving beyond a reasonable doubt to a jury facts that justify the increase. That raised a second question: what should be done instead? Justice Ginsburg, one of the 5-member majority, broke with the majority on the remedy to join with the dissent to give them the majority on the remedy. 1. Sentencing guidelines would operate as they did before, but they're now advisory, not mandatory as they were before Booker. And 2. Sentences are still subject to review by the U.S. Courts of Appeal. In Gall v. U.S., the first case to apply the Booker Rule, the 5-member majority upheld the trial judge's sentence of Brian Michael Gall to 36 months probation instead of a mandatory prison term. There is the abuse of discretion standard, which, quote, provided a failure to exercise sound, reasonable, and legal decision-making, an appellate court's standard for reviewing a decision that is asserted to be grossly unsound, unreasonable, illegal, or unsupported by the evidence, end quote. Because the guidelines are now advisory, appellate review of sentencing decisions is limited to determining whether they are, quote, reasonable, end quote, in the United States v. Booker, 2005. And an abuse of discretion standard applies to appellate review of sentencing decisions. Here's the next discussion activity for you to consider. The Supreme Court held in U.S. v. Booker in 2005 that sentencing guidelines are advisory only, but enjoy a, quote, presumption of reasonableness, unquote. If the sentencing guidelines are advisory only, then what good are they? And what does a, quote, presumption of reasonableness mean?
Here are some key cases that I'm going to mention and you need to read more about, but I'm going to tell you about them. The first is State v. Metzger in Nebraska in 1982. The Nebraska Supreme Court held that a Lincoln, Nebraska city ordinance that made it a crime to, quote, commit any indecent, immodest, or filthy act, end quote, was void for vagueness. The second is the Commonwealth v. William P. Johnson and Commonwealth v. Gail M. Johnson in 2014. Gail and William Johnson appealed their conviction of criminal harassment as applied to cyber harassment. The next case is Woolard v. Gallagher in 2013. Raymond Woolard, a handgun owner and a Second Amendment advocacy group, sued state officials alleging that Maryland's, quote, good and substantial reason, end quote, for issuing a handgun violated the Second Amendment. The next case you need to read about is Lawrence v. Texas in 2003, where the U.S. Supreme Court struck down a Texas statute that made homosexual sodomy a crime. The next case is Kennedy v. Louisiana in 2008, where the court decided that executing Patrick Kennedy was, quote, cruel and unusual punishment, end quote, because it was disproportionate to his rape of his 8-year-old stepdaughter. The next case is the State v. Nynum in Wisconsin in 2011. The Wisconsin Supreme Court upheld Omer Nyman's death in prison sentence for the horrific intentional murder of 13-year-old Zong Vang Nam, committed for murder when he was 14. Ewing v. California in 2003, where the court upheld the constitutionality of California's three strikes law. And the last case you need to look at is Gall v. U.S. in 2007, where a 5-member majority of the Supreme Court upheld the trial judge's sentence of Michael Gale to 36 months of probation instead of a mandatory prison term. Class, thank you as always for your time. If you have any questions about anything we covered in this chapter, please make sure to contact your instructor, and we'll see you next class.